Asylum. 3 things you must know prior to applying for asylum. In this video, we'll talk about the must know. Bijoux Ngwanda here, immigration lawyer in the DC metropolitan area. If you're new to my channel, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing. And please don't forget to hit the notification bell so you don't miss any of my videos. If you enjoy the content, please go ahead and share, like, and don't forget to comment below. And please go ahead and share, like, and don't forget to comment below. I have to reiterate because we're trying to gain a lot of subscribers this year. This is the year, right? This is the year where we have to get to 20,000 subscribers, and this is the year where we hope that this Biden administration will finally come to their senses and do something about this immigration reform. But in the meantime, let's talk about asylum. 3 things you must know prior to applying to asylum. The number 1 is asylum is a discretionary measure. So when you apply for asylum, you have to be prepared on whether they're going to grant you or whether they're going to deny you the case, because it doesn't really matter the weight of evidence that you have. What matters is those discretionary factors, right? The judge, if you are in removal proceedings, right, the judge will examine, okay, the claim of asylum and weight those discretionary or negative factor in order to apply their discretion. So they will weight the weight of evidence. So weighting it, looking at those evidence, the credibility of your story, your testimony, whether it passed the test of time. At that point, the judge will decide. And sometimes people have good evidence, but the judge go against them, denying those cases. That's when it comes to discretionary. It's not a mandatory relief. Really, it is discretionary. It's up to the judge to use properly their discretion. But if the judge abuses their discretion, then we move to appeal that decision, and sometimes we even go further. Even the BIA, the Board of Immigration Appeal, wants to deny that appeal. We can move, if you meet those criteria, to review that case in federal court. So that's how asylum works in terms of discretion, okay? But when you are with the USCIS officer, it's the same thing. Discretion. Asylum is a discretionary relief. So the USCIS officer, again, will wait on the credibility of your story, wait on the evidence, wait on the testimony, your own testimony. And if you meet really the test of time, you pass the test of time, then they will use their discretion. Discretion, that's the key word there, discretion. So basically they can grant it or deny it. So it's not a mandatory relief. In other words, it's not like if you have all the evidence, they must give you asylum. Unfortunately, with asylum, it doesn't work like that. With asylum, really, whether you meet those evidence or not, it's a matter of discretion, okay? But it's good to meet those, really to meet all the requirements so that they can use a favorable discretion on your behalf. That was number 1. It's too long, right? Number 2, timing. It is important that you know about timing prior to applying for asylum. Why? Because asylum must be applied within 1 year of physical presence in the United States. Once you pass 1 year, then you can actually apply if you have one of those exceptions, if you meet the exceptions, okay? Exceptions, if exceptions apply, then you can apply for asylum after 1 year. What are those exceptions? We're going to talk about changes of circumstances in the country of origin of the applicant, or extraordinary circumstances beyond the control of the applicant, and those circumstances led the applicant to apply late. We've talked about it before. I mean, you can just go ahead and refer to my previous video to know more in detail what are those circumstances that can really qualify someone to apply for asylum late. Number 3, the last thing you must know about asylum is you cannot file a frivolous asylum case. You cannot file a frivolous asylum case. Simply means that the application or the claim itself, the essential element of the claim has not to be really misrepresented. So you cannot lie on the material things. Let's say, for example, someone is talking about they flee their country because they were involved in some political associations, and then they got arrested. They fear if they go back, return home, they got arrested, they got detained, they got tortured, right? So if they go back home, they will be subject to the same treatment, torture, detention, and probably they're gonna get killed. But if they verify and find out that you were not part of that association, so basically the material, the central thing of the claim is a lie, false, misrepresentation, then the judge will conclude, or the USCIS officer, I believe in those circumstances, mostly the judge will conclude that this case is frivolous. And once the case has been concluded that it is frivolous, my friend, you will not be able to apply for any other benefit. No waiver is really available in that case. Really, there are really limited waivers. In other words, really, out of 100, probably only one person has got the waiver granted. And if you look closely on the fact of that person's case, probably maybe the person did not have the opportunity to actually defend themselves to prevent that frivolous claim from being filed. So you have to be careful when you're applying for asylum, and you have to remember those 3 things. Those are not the essential in terms of, those are not the only things that you have to remember, but important things that you have to remember to prevent you from reapplying from any other type of benefit. That was it for today, my friend. We will be talking about a lot of must know in a lot of area of immigration law, and in the near future I'll be introducing myself as a DC family law attorney, matrimonial law, talking about custody, child support, visitation rights, divorce, why not alimony, and why not all that entails family, because we know that immigration intertwined with family. As we handle already family-based immigration, we can help those in the DC District of Columbia, because you know family law is state specific, so we can handle those cases. But stay tuned, I'll let you know when the time comes. If you need a consultation, okay, I was about to forget this one. If you need a consultation, please call my office, 202-751-2180. Consultation fees apply as usual. Until next time, bye-bye.